Welcome everyone to the Texas PACE Authority's monthly third Thursday at 2 training series. Today we're going to cover the topic of leveraging non-PACE financing and crediting mechanisms. My name is Dub Taylor. I'm the Chief Operating Officer for the Texas PACE Authority, and I'll introduce our guest speaker here momentarily. Let's see, there we go, thank you. So for today's webinar, everyone is muted and their video is disabled. So please use the Q&A at the bottom of the screen and have any questions, log those there. We will try to get to all those before we adjourn today, and try not to use the chat, but use the Q&A. This recording will be available on the TPA website and our YouTube channel after the webinar today. If you attend today, you can request a PDH certificate for the hour that you're attending, and you'll also receive a survey after this, so that will provide the instructions on how to request that PDH certificate. And just to announce some upcoming trainings we have under the T5 series, next month will be an in-person, not a virtual, not a Zoom training, but in Amarillo. We will be meeting at the newly opened Barfield Hotel, which is a PACE-funded project that has taken an older office building in downtown Amarillo and turned it into really kind of a showpiece, a beautiful boutique hotel. So we'll be touring that, as well as having training sessions both for contractors and service providers, as well as owners in Amarillo on the 21st. So if you're in the region, please plan to attend that. You'll be seeing more information from us on that soon. Then on the 18th, the program guide that TPA currently has published is not completely aligned with updates made to the technical standards that are published by Keeping Pace in Texas. Those were updated recently. So we'll be updating those, and on the 18th, going over those changes. And then on the 16th of December, in partnership with the U.S. Green Building Council's Texas chapter, we'll be learning about their best practices app. So that'll take us through the end of the calendar year, and then we'll plan a schedule for next year as well. Go on to the next one. Again, Dub Taylor, I'm the Chief Operating Officer for TPA. Prior to TPA, about a year and a half ago, I retired from the state after 21 years running the State Energy Conservation Office, and there managed engineering and technical assistance and financing programs, all public sector. So PACE being private sector. Working on the other side of the fence now, and it's been great. A lot of activity, and in spite of COVID, a lot of projects in the last year and a half, and a lot of new programs. Next. So TPA is a nonprofit. We were established specifically to administer PACE programs on behalf of cities and counties across the state. That's all we do. We have no other role in the projects, but helping educate owners, property owners, capital providers, and service providers on how PACE works, what the opportunity is with PACE, and then representing the cities and counties, ensuring that the PACE transactions are compliant with state law and guidelines. Next. And the PACE market in Texas is growing. The model here is cities and counties have the authority to create PACE programs, but they have to go through a couple of steps to adopt it. And we now have 63 local PACE programs, just several new ones this month already, covering more than 60% of the state's population. So more as word gets out that this is a great economic development tool to have in the toolkit, more cities and counties are adopting PACE. Next. And so the problem, again, just to sort of step back and what are we trying to address here? Business owners know that they can save money by investing in certain types of energy and water savings upgrades to the property, but these upgrades are expensive, and they have competing needs for their internal capital. And so oftentimes these projects either don't get done or they get done in a piecemeal fashion, which means that buildings really operating as systems wind up suboptimized. So you aren't really squeezing all the efficiency opportunities out of buildings and out of these projects unless they're done in a comprehensive fashion. So PACE, being a financing mechanism really designed for larger scale projects, can provide the capital to do those types of more extensive retrofits. The other result of really kind of not addressing this problem is that inevitably your AC system fails not in November or in April, but in July or August. And so typically you wind up having to replace that equipment on an emergency basis at a premium. Maybe it's equipment that you otherwise would not have specified because you have to take what's available. And so again, this is a way to do this in a more planned way. And then by not addressing the problem also, you've got higher operating costs for utilities and maintenance. The building itself performs lower than it should in a number of different areas. You have indoor comfort challenges with temperature control and lower productivity in the case of manufacturing. So next. So PACE, a solution, like any other solution, it is not the silver bullet, but it is a terrific way of addressing these issues. And it can be part of a larger project, part of a larger capital stack, which is what our presenter is going to be talking about shortly. PACE is an innovative financing tool that can provide 100% financing for certain energy, water conservation, and distribution projects. It's private financing secured by a special assessment that is in place for the useful life of the improvements. So it is not governmental funding necessarily, but it is a governmental conduit that allows otherwise what would be a private transaction. Local government enabled, as I'd mentioned earlier, and it's voluntary and open market, meaning that any property owner within a PACE district, a PACE region, can decide they want to use PACE if it makes sense for them. And any contractor can do the work. Any capital provider can provide the funding. So again, it's really a conduit to enable these private transactions that otherwise are not occurring. And the types of properties we're talking about here are commercial, including nonprofit, commercial buildings, multifamily, 5 units or more, and industrial properties, manufacturing and agricultural. About the only kind of property that's not eligible is single family residential or residential up to 4 units. Next. So we see PACE, you hear win, win, win. It's really a win times 5. Property owners win, contractors win, lenders, the state sort of at the higher level by reducing peak demand, not only in the summer, but in the winter. It wasn't that long ago that the entire state was shut down Valentine's week or the week after that with an unexpected winter storm. So we can help reduce peak demand and keep the grid more reliable. And then again, for communities, this is a tool for economic development. This allows reinvestment in the community and allows owners to make those needed investments in their building stock. Next. And so with that, I'm going to turn it over to our guest presenter today, Phil Gahabe. Phil is a shareholder with Munch Hart in Dallas. He is truly an expert on real estate financing transactions, complex real estate structures for public and private owners. I can tell you this, he has forgotten more about this topic than I will ever know. So that's why we have him as a guest presenter today. I'm looking forward to learning as well as you from what he has to tell us. He is a leading expert on PACE financing in the state, having been involved with and closed over $100 million in projects since 2017. And like today, he regularly presents at state and national audiences on PACE and how it can be an integral part of a capital stack for projects. So with that, Phil, I will turn it over to you, and thanks for joining us today.
Well, hopefully I'm not going to disappoint with that wonderful introduction. Hey everyone, my name is Phil Gahabe. I am a shareholder at Munch Hart Coffin Hart in Dallas, Texas, and I specialize in public-private partnerships. So Munch Hart is a full-service law firm based in Texas. We have offices in Dallas, Houston, and Austin, and we cover not only the state of Texas, but we also do work around the country. My specialty is in what I like to call creative capital. So a lot of times clients will come to me with a redevelopment project or something they're trying to accomplish, but they just don't quite know how to finance it. And so part of my job is to help them identify sources like PACE and others, tax credits, TIF, incentives, et cetera, that can help get a project done. And so today what we're going to be talking about is how to leverage non-PACE financing and other credit enhancements into a very complicated capital stack. And we're going to show you a couple of transactions that we've closed over the years that I think really illustrate some of the flexibility and honestly some of the restrictions that PACE loans provide. So we have a couple objectives. So first, we're going to learn about what is the legal status of a PACE loan. We're going to identify potential sources of non-PACE capital that play well with PACE, and also identify some critical negotiation points. Because of the statutory restrictions for PACE loans, there is definitely sort of a specific parameter that you have to hit in order to include PACE within your complicated capital stack. So a couple of key features, and I think Dub did a good job of giving you the forest from the trees. First, a PACE loan is secured by a voluntary assessment lien that under Texas law has the same priority as a special assessment. That special assessment cannot be accelerated upon a delinquency or an event of default. The only amount that is collectible by a PACE lender is what is then due and payable or delinquent. 3, the PACE loan assessment amount is based on sort of achieving a minimum savings to investment ratio, can't exceed the cost of the qualifying improvements plus the carry cost associated with that. And then as an outside governor, there's this 25% as completed appraised value without a waiver from the PACE administrator. Now, I will say there's a footnote at the bottom of the screen. There is some recent guidance about how the TPA sort of evaluates that 25% as completed appraised value. And I'd encourage you all to sort of look at the guidance. Also, state law requires a mortgage lender's consent. In addition, PACE is this weird hybrid. A lot of people treat it as a loan, essentially between 4 and 7%. We'll get into that, amortized over sort of a particular period of time, usually 20 to 25 years. And that's dependent upon the useful life of improvements that are installed as a part of the qualifying improvements for the project. But it's also a real estate tax. So from GAAP or other accounting perspectives, you may be able to treat it differently. And it could also be treated differently for some of the users or tenants or guests that you may have coming to your property. So it's just important to understand the flexibility and the legal treatment of the assessment. PACE assessments can be passed through to tenants under a triple net lease. There are lots of tenants who are getting wise to sort of their landlords passing through the assessments. So sometimes landlords and tenants negotiate specific restrictions on PACE assessments to avoid that. In addition, if you're going to visit the Barfield, which is a project that we worked on a couple of years ago, you might see on your folio a green fee or some kind of extra charged to hotel guests or users of a particular building. And that is honestly one of the ways that we see that PACE assessments kind of have the project pay for those, through cash flow in the project. In Texas, a PACE assessment cannot be used for new construction unless the lot under development is not, quote, an undeveloped lot. And again, there's additional guidance that TPA has issued related to what is considered an undeveloped lot that you should review if this is a question you have. Also, PACE assessments cannot be used retroactively unless a developer had a present intention to use the PACE financing during construction, had some kind of meaningful dialogue related to the use of PACE financing. Again, there's additional guidance that was recently issued that you should consult if this is something you're considering on a retroactive basis. And we actually have a very good example of that later in the presentation. Finally, PACE loans, you can either obtain what's called a direct loan from a capital provider, or you can get this through a bond issuance. So there have been 2 transactions to my knowledge in the state where they've actually had an out-of-state bond issuer issue bonds and then loan the proceeds of the bonds to the project. And really, at the end of the day, if it's a direct loan versus a bond issuance, it's more about the secondary market and how the PACE capital provider intends to securitize the instrument and thereby reduce the cost of capital. What I will tell you is that bond issuance transactions are a lot more expensive up front, but sometimes they can offer lower interest rates than, say, a direct loan can. All right, so we have this program, and why do developers use it? So we helped close one of the largest PACE transactions, one of the first, I think, in the state, called the Butler Brothers building. And this is a good example of why they did it. In the before column, we had a capital stack that showed, essentially a weighted cost of average of the capital of 9.29%. But after closing, we were able to refinance a very expensive mezzanine loan with the use of a PACE loan that reduced a 15% interest rate to a 6.13% interest rate. That reduced the overall cost of the capital to a weighted average of 7.46. When you consider the life of the PACE loan and the life of the asset, that is a huge interest savings. And so developers who are thinking about trying to find cheaper costs of capital in order to get, add to their promote are always trying to find sources that can play well in this mezzanine space in order to sort of get their deals done. In addition, PACE permits owners to amortize the cost of those improvements over the life of the improvement. So if you intend to keep the PACE loan on the property, the investment you make now can then be passed on to your owners so that you're not fronting all of the cost, as Deb sort of discussed earlier. Also, the treatment as a special assessment permits successive owners to pay for those benefits over time. And that's also important in terms of the long-term life of the asset. The energy efficiency and water reduction reduce operating expenses. And so part of the SIR calculation that we calculate before the PACE loan is put in place is trying to make sure that essentially the savings generates enough cash in operating expenses to pay the assessment over time. And that's really just sort of the theory of the lien assessment. Because of its priority, a PACE assessment is less expensive than a lot of other forms of mezzanine debt or preferred equity. We're going to get to a second about the legal status of PACE loans, but because of their super priority, it permits a lower cost of capital for the project. In addition, most PACE lenders underwrite projects based on eligibility. And while they are concerned, like traditional lenders, on project cash flow and debt service coverage ratios, et cetera, a lot of times they're just looking at project eligibility because they know that super lien priority protects them in the event the project experiences some kind of cash shortfall. PACE can't be combined with a variety of other real estate incentives, and we're going to get to that in this presentation. So what exactly are these things? I mean, we've called them special assessments, we've called them contractual assessments. Well, this is the actual statute. It is a contractual assessment. It is a first and prior lien against the property. It has the same priority against all as an ad valorem tax. The lien runs with the land. It can be enforced by the local government just like a property tax lien. And they are delinquent assessments or incur interest and penalties the same way that a delinquent property taxes would. What does this mean? According to the Attorney General, this means that this is considered a special assessment with the same lien priority rights and delinquencies and recovery costs as a real property tax. And this Attorney General opinion was very useful for the PACE market, as some of us were attempting to provide legal opinions in connection with determining what does a contractual assessment truly mean under Texas law. Now, the effect of that, though, is pretty dramatic. Under the Texas tax code, if a tax lien is foreclosed upon, the deed that is received upon that tax lien foreclosure essentially wipes everything out, except for any rights of redemption that the borrower may have, which they don't under the PACE statute, restrictive covenants that are filed with a certain date, and any recorded liens that arose in connection with those restrictive covenants. So think of HOA fees, subdivision fees, things like that. That's what that was intended to protect. And then each valid easement of record, so we think utility easements. Notice things that are missing from this sort of statute. Leases and possessory rights are not included as protected interests. In addition, first lien mortgages for other private capital are not protected. So the legal effect of a foreclosure of a PACE lien means that regardless of any private agreements that the PACE lender may have with a tenant, with a lender, or anybody, all of those can be wiped out by the PACE loan. And that presents a particular challenge when we're trying to work through a complicated capital stack where you have equity interests competing with private loan interests, and now we have them competing with essentially voluntary contractual assessments that are treated as special assessments under Texas law. All right, well, getting to the meat of our presentation today, we're going to talk about several different types of alternative sources of capital that are commonly used with PACE loans. So we're talking about historic tax credits, low-income housing tax credits, new market tax credits, preferred equity structures, opportunity zone investments, ground leases, and in some cases, city grants, TIFs, and loans. A couple of things to kind of keep in mind as we're walking through the examples for the projects that we're going to talk about today are: one, the super priority, the tax sale process, and some of the bankruptcy protections afforded to PACE loans. Two, the inability of any of a private capitalator to forbear on remedies due to certain statutory deadlines required to perfect their liens. And three, there's sort of an emerging market now where private lenders, first lien lenders, are requiring recognition agreements, which attempt to get to some notice and cure rights and some ability to have just know what's going on with the PACE assessment. But at the end of the day, those are private agreements that don't necessarily track with the foreclosure process of a PACE assessment. Further, capitalized interest and other fees and how that's handled within a complicated capital stack. And finally, how does the lockout provisions in PACE loans, as well as release of collateral and loan modifications, could work in a loan workout. So the first person in a capital stack that's probably the most important other than your equity is your first lien debt. And the statute requires all first lien lenders to consent to any PACE loan that will be imposed upon a property. The statute says that you have to have at least 30 days prior written notice to that lender, and they have to consent to it. And that is a sort of a hard and fast rule that we try to follow in every one of our closings to make sure that the lender fully understands what the priority of that PACE loan is going to be. So why do mortgage lenders consent to these things? So the first step is that the PACE assessments themselves are only for sums which are due and payable and delinquent. If you have a $10 million PACE assessment and $500,000 is due in any given year and it's not paid, the lender doesn't have to pay $10 million to secure their position. They just have to pay $500,000. And so what we call that is that there's no ability to accelerate the PACE assessment, which helps get senior lenders comfortable with the risk that they're only going to have to pay 1, maybe 2 years worth of PACE assessments. So many times what lenders will do is establish healthy tax reserves as well as healthy PACE reserves to make sure they have enough cash collateral on hand to make that PACE assessment. Second, PACE assessments do not affect the ability of the lender to foreclose on the real estate. So just like the PACE assessment following the successive owner, it will follow the lender or its designee in the event the lender either forecloses on the property or they sell the property at a foreclosure sale. Third, PACE assessments can be reserved like monthly like taxes, and that's pretty common. Fourth, if the SIR is greater than 1, then theoretically that means that the savings should actually increase the net operating income of the property and thereby improve the collateral over the long term. We have actually seen some of our borrowers negotiate this item with appraisers since it helps increase the net cash flow and thus increase the value of the property. More often than not, what we see is that lenders are willing to provide capital to projects that have PACE loans involved with them, but they're going to give you a little bit lower leverage. So if they were going to give you a 60% loan, but you want a PACE loan, you're going to go down to probably 50% on your construction loan, and then a 25% PACE loan. Now, in the 60-40 model of a capital stack, that's 40% equity. But in a 50-25% of the capital stack, that's 25% equity. And for those of you who are real estate investors, the difference between adding that 15% in equity can make a massive difference on sort of the returns that you're expecting from your capital. Finally, PACE loans are available as the date of closing. So there is, in terms of who gets to fund first and the disbursement procedures, some lenders and PACE lenders agree to fund pari passu pro rata, which means that they fund at the same time the proportion of the project that's being completed. Other lenders require that the PACE lender fully fund the project and then they'll fund their dollars last, sort of treating the PACE loan like equity or a mezzanine loan. There are some compliance tricks to a fully funded PACE loan, since the statute requires that the PACE loan be used to fund qualifying improvements. But because of the ITPR requirement at the end of the project, we can usually include like a rebalancing provision in case the cost for those qualifying improvements didn't necessarily bear out with sort of the initial modeling of the transaction. All right, so now we're going to get to some of the fun stuff, because we're going to talk about actual projects, not sort of theoretical, sort of, this lender has first lien on what. So the first one I want to talk about is an exciting project in Deep Ellum, Texas, in Dallas, called the Continental Gym Building. So the Continental Gym Building is a project that's located in Deep Ellum, and it's listed on the National Register of Historic Places. It used to be the home of the Continental Gin Company, which was at one time the largest manufacturer of cotton gins in the United States. So the renovation plan for the building was that it was formerly used as sort of an art exhibition center. And so our client had a vision to turn this into essentially creative office, and to create a sort of co-working space, and then some suites at the top, and then retail on the first floor. The key to this analysis, though, is that there was no key tenant identified. All of this was, by the way, pre-pandemic, and they did not have like an anchor tenant that would have made the project sort of pro forma immediately. So that led to some challenges from raising capital, because most construction lenders want to see a key tenant for an office project. So one of the first things that we had to do was to sort of go to the city and sort of determine what the rehabilitation plan was for the project, which included reviews from the National Park Service, the Texas Historic Commission, the Dallas Urban Design Peer Review Board, of course, the Texas PACE Authority as the administrator for the city of Dallas. And they decided that they needed to do things like replace exterior windows, a new HVAC system, new electrical, water efficient systems, and a new roof with solar panels. So when we projected this, and this is a calculation of the SIR, of the savings over the term, the total cost of those qualifying improvements was approximately $10.4 million, but the savings over the useful life of those improvements was projected to be in the ITPR 11.3. So generating a savings of 1.09, thus qualifying for the financing. So in order to get our capital stack rounded out, we had a couple of different sources we had to think through. So the first one was our sponsor equity, which was also a qualified opportunity zone investment. And for those of you who don't know, in certain census tracts designated in the state of Texas, if you take capital gains and you invest them in a qualifying asset, then you can get essentially some step up in your basis for your initial investment and save taxes if you hold it for more than 10 years. It's a very simple way. The program's a lot more complicated. Give me a call if you have questions. But the second source was federal historic tax credit equity, state historic tax credit equity. We received a $3 million grant from the city of Dallas, a PACE loan, a first lien loan, that's that Frontier State Bank loan, and then we had a sort of a deferred developer fee, which is common in historic transactions. So as you can tell, this project was complicated, and really at the end of the day, there were several tension points. So first and foremost, we have a federal tax credit investor over on this side of the deal. Hold on one second, let me get my fancy pen. They were primarily concerned with making sure that they keep their tax credits through their 5-year compliance period. Obviously, if the PACE loan is going into default and they're threatening foreclosure, they're really concerned about that. Federal tax credit investors typically obtain what's called a subordination non-disturbance agreement or a forbearance agreement, which would prohibit a first lien lender from foreclosing the property during the compliance period. In this case, a PACE lender cannot agree to any of that, because when they send a notice to the county to start the foreclosure process, they lose control over who actually buys it and what the process is, because that's just how the tax lien foreclosure statutes work in Texas. So the federal tax credit investor had to get comfortable with the underwriting risk that it would not be able to pay the PACE assessment that was then due over the term of the loan. And given the fact that we had to establish cash reserves for the PACE loan to give the federal investor some comfort that in the event they did have to take over the project, they would be able to step in and fix the problem. The second issue we had was obviously we have a construction loan. So the construction lender had to consent to the PACE loan. So in order to consent to that, they obviously agreed to be fairly low leverage. I mean, for those of you who are in the real estate business, typically a first lien loan is 60% of your capital. Here, it's about 34% of the capital. Because of that low leverage, the bank was also very sort of more lenient on sort of providing these other areas, these other incentives to the project. And also that PACE loan kind of helped make the project work from a capitalization perspective. Since this was a sort of a spec office project, the first lien loan was actually more expensive than what it is now. And so the PACE loan was slightly more expensive. I think it was only 25 basis points more expensive. And so this was actually a very efficient way to sort of put the first lien capital into the deal. And then when you also add the PACE loan together with Frontier State Bank, you get it to be about 50% of the capital stack. So all of that to say that it was sort of a complicated way to sort of navigate between those two programmatic requirements. First, the compliance period on the federal tax credit investor, and second, a construction lender's hesitancy for even investing in a project that is spec office, but also, you know, from a capital perspective, reducing that overall cost of the capital. Now, we were lucky in that we were in the city of Dallas, so the city of Dallas was also our, what do you call it, the municipal, our local government that was sponsoring the project. So they were excited to see us using a PACE loan and them also providing additional subsidy to the project. But when you're approaching cities, what we're finding is that cities, now that the PACE program is so prevalent within the state of Texas, the question we get is, well, I see your but-for test, I see your pro forma, but now I want to see you put a PACE loan into that because that is a low-cost source of capital we know that we can provide you. And we want to see that before you come to us and ask for grants and other incentives. So a lot of jurisdictions, Houston, Austin, and others are starting to take a similar approach now that this economic development tool is now in their toolkit. All right, so let's see here. We're going to clear this, I think. All right, the Qualified Opportunity Fund, at the end of the day, this is equity. And equity sometimes requires recognition agreements with construction loans or with PACE lenders. In this case, similar to the federal tax credit investor, they were not given any sort of recognition rights or extra cure or sort of periods with the PACE lender. So a lot of times they'll ask for, say, 60 extra days if there's a default. And the reason they ask for that is so that they have the opportunity to come into the project, maybe change the developer, change the contractor, cure a default, and they just, obviously that doesn't happen overnight. Unfortunately, if you miss a PACE assessment, a PACE lender under the Texas statute has a very limited period of time to certify a default and a delinquency with the local government, such that the local government can then take a tax lien enforcement action. So one of the ways that we try to navigate this timing issue is, instead of payments being due January 31st when the taxes are due, we have the payments due, say, December 1st of the prior year. And by moving that date about 60 days, that gives some breathing room for the parties to kind of figure out, how are we going to navigate, say, a workout, or how are we going to navigate making the PACE assessment payment in any given year. And moreover, a lot of PACE lenders now are moving to a multiple payment in a given year. So some, more often than not, I see a semi-annual payment, say June and December. And really that kind of protects the borrower from giving them as much time as they can, so that the PACE lender isn't forced to put a project into default and then start a foreclosure action that they don't really want to start. A private lender like this construction lender, you know, they have all the time that they want to give the borrower to fix a problem. PACE lenders don't have the luxury of time because if they don't certify a delinquency by a particular period of time, then they may lose their rights for a whole year. And that's not going to be good for any of the PACE holder, the holder of any PACE paper. All right, let's turn that off. Okay, so the next project I'd like to talk to you about is called Redbird Mall. So for those of you who are in Dallas, this is the former Southwestern Center Mall located in southern Dallas. The project is a multi-phase, multi-asset, separately financed, several components, all within the sort of same former mall campus. It includes anchor tenants, low-income housing tax credits, key anchors for major tenants like UT Southwestern and Foot Locker, pad site retail, as well as a new hotel that's also being planned for the project. This project was recently awarded, Business Journal's 2019 Deal of the Year. So it's a $175 million project, and it's sourced with a combination of sponsor equity, cash grants and loans from the city of Dallas, TIF subsidy, as well as 4 separately collateralized senior loans, a mezzanine loan, a new market tax credit investment, and, drum roll please, a PACE loan. So one of the key problems of the project was the inline mall. I mean, it's very easy to figure out what to do with the anchor stores. So here we show the anchor store, like here, like this north, this was a former Macy's, this was a Sears. We can convert those to single tenant spaces very easily. But how do you deal with small retail spaces and a sort of, central corridor that is essentially the heart of most malls, but for a dying mall, how do you fix that when those small tenants are essentially leaving the building or frankly don't pay the rent to support a large senior construction loan? So in addition to that, the mall had already done some energy efficiency improvements, but it needed a new chiller because the HVAC system was wildly inefficient. And when they were looking at their operating expenses, they knew they had to make a substantial investment in the HVAC system to drive down the cost for operating expenses for all tenants within the mall. So the best way to explain this project is honestly through this spaghetti chart of how the money actually went into the deal. So this has a lot of different pieces, so I'm going to walk you through it real quick. So first and foremost, we had the city of Dallas providing certain grants to the project. We had a new market tax credit allocation for a portion of the renovation of the mall, which was specifically for tenant improvements for a certain key tenant for the mall. We had a senior lender who was loaning assets outside of the mall, but because they had consent rights to certain things occurring in the mall, they had to be involved in the transaction. A mezzanine lender who had a lien over essentially the entire project and whose consent rights needed to be navigated under the terms of their loan agreement. And then when we look over here, we see Texas Security Bank having a first lien on the mall and a PACE loan being provided to the mall. So obviously this creates a lot of complication for the project. And what I'm going to do, if I can ever get this to work, is to show you exactly what the PACE portion of this project was. So we have a senior lender, we have a PACE lender. Senior lenders providing some capital to do general renovations of the mall, as well as new TI space for a new tenant. And we have Twain Financial providing a PACE loan against the mall in order to fund energy efficiency improvements that had already been made to the project, as well as a new chiller. We had small tenants that we had to sort of deal with, but more importantly, we have a master lease involved with a new market tax credit structure right here. And then we have a direct lease to a key tenant. So similar to those recognition agreements that I can't give to most people, a PACE lender can't give a subordination non-disturbance agreement to a major tenant, because under the statute, any third-party agreement is going to essentially be wiped out by a foreclosure. So it's hard for Twain to sort of say, start the foreclosure process, and I don't know who's going to own it, if that makes sense. So one of the things that we had to negotiate with both Chime and the master lease was essentially some notice and cure rights as between the landlord and the tenant. So if if they got a notice that the PACE assessment wasn't paid and the landlord provided them notice that we're not going to pay it, the tenant would have the ability to pay the PACE assessment and offset against other amounts due under the lease. Obviously, that's not a great solution to the problem, but that was frankly the only one that we found palatable to Twain as well as the other key tenants in the project. In addition to that, we have a new market tax credit structure here, and you can use PACE loans as leverage for a structure. However, you can't give that PACE lender a direct lien on the project. So here, the new market tax credit lender actually had a mezzanine pledge of assets that were outside of the mall, as well as membership interests. And so by structuring it this way, we sort of were able to use the PACE loan as a source of some of the leverage for the leverage loan, for those of you who know new market tax credits. And it ended up working out that this structure has been replicated in other states, but it's hard to sort of master, only because a lot of times the new market tax credit lender is concerned about, well, what rights does the PACE lender have to wipe them out? And similar to a federal historic tax credit lender, they're also very concerned about keeping their tax credits in place during a compliance period. So one thing to sort of attempt to navigate. In addition to that, we had a mezzanine lender who was over the entire project, and obviously they also could not get a recognition agreement. So one of the ways that we had to work through that risk with them, in addition to the risk with Texas Security Bank, was to provide low LTV loans, as well as more cash collateral for the PACE loan, to make sure that the PACE assessment was never going to sort of go into default. And if it did, there was adequate cash on hand to actually pay the PACE assessment. So the next project that we're going to run through real quick is called the Sinclair. So the Sinclair is a 164-room autograph collection by Marriott Hotel located in Fort Worth, and it was originally closed with federal and state historic tax credits, a substantial subsidy from the city of Fort Worth, preferred equity, sponsor equity, as well as a construction loan in 2017. Unfortunately for this hotel, it opened in November of 19, and then obviously, as we all know, and the reason why we're doing a Zoom call right now, I'm sure, in February and March of 2020, the revenue of the hotel dropped. The hotel was forced to shutter as a result of governmental orders by the city of Fort Worth, and obviously wasn't generating any revenue and went into financial default under the terms of its construction loan. I will note that this building is beautiful. If you ever visit Fort Worth, it's actually one of the most technologically advanced buildings in the United States. It's got a special LED lighting system that they use and can control from a central computer. So this was a workout. We were approached by the current sponsor of the project and asked to assist them with trying to recapitalize the whole project in order to repay the construction loan, certain preferred equity, and to keep in place a federal historic tax credit investment through a combination of new preferred equity, a new mini permanent first lien loan, ground lease financing, and a PACE loan. So in this case, the PACE loan was used to recapitalize a project that had already been completed. And part of the underwriting for that project was working with TPA to show that the owner had intended to utilize PACE financing at some point during the construction of the project. So the owner actually, I believe, had filed an application with TPA, I believe, to sort of use PACE financing earlier on in their construction process, but ultimately elected not to move forward with it. So since we were within the 24-month window of when the project was completed, and it was completed in 19, we were able to qualify to use this for what in the market is called a retroactive PACE loan. Now, one of the special pressures of this deal was that since the senior loan was in default, all of this had to happen in 90 days to avoid more foreclosure mess from the construction lender. So let's talk about what ground lease financing is, because it's kind of a unique financial product in the market. So ground lease financing is really a debt vehicle where the lender will take fee simple title of the property for a purchase price equal to the land plus the improvements, and it will lease the property back for 60 to 99 years. And the purchase price will then be used to benchmark the rental rate, and the rental rate will escalate based on an agreed upon escalation factor. The owner and lender typically negotiate like a purchase option, so essentially a way for the former owner to get the property back, like repay the loan. And the benefit to the lender is that it receives better security since they own the real estate, while the owner gets to retain the tax ownership for depreciation and other purposes. However, this is really a bridge financing mechanism. It's an expensive, it can be very expensive capital, because when you factor in those escalations over, say, a 10-year period, right around year 6 or 7, it becomes far more expensive than just obtaining traditional first lien debt. So one of the things that the PACE loan provided was the ability to buy down the cost of that ground lease with a lower cost long-term financing that was amortizable over a 25-year period. Here is the structure chart. And what you can see here is that we have a ground lessor that's made a lease to a project owner. We have our master tenant historic tax credit project. Similar to the Continental Gym Building, the federal tax credit investor could not get any kind of recognition agreement with the PACE lender, but the PACE lender, the PACE loan was sized to a point with certain operating reserves and other cash on hand to make the federal tax credit investor comfortable with how the project would be managed. Here, the senior lender and the PACE lender are both leasehold mortgages or leasehold assessments. And what is unique about that is that you can have a PACE loan secured by a leasehold interest. And I believe it's probably been done probably a half a dozen times in Texas for transactions that I know about. And there's several key considerations for using a PACE loan on a leasehold interest. Under Texas case law, we need to determine who owns the improvements. The Texas PACE statute requires that the person obtaining the PACE loan has to own the qualified improvements in order for it to qualify for a PACE loan. So the ownership of those improvements is the critical sort of step in figuring out if a ground lease is going to work. So first off, during the term of the lease, how is ownership of the improvements treated? Sometimes for tax purposes, it's for the ground lessor and then they pay the real estate taxes. More often than not, a ground lease, given its long term, is treated as ownership for the tenant. I'll give you a hat tip that, for example, for DFW industrial leases, a lot of times DFW retains the actual ownership of the improvements. So sometimes a PACE loan may not work in those projects, although I'm sure there's a way we can negotiate around that. Another key step is, does the lease exceed the useful life of the improvements? So here we had a 99-year lease and we had 20-year properties, so clearly it qualified. Who is responsible for paying taxes? And this gets to the last bullet point too, which is, does the leasehold interest have a separate tax identification number? Under Texas law, you can apply to an appraisal district to segregate the ownership of the land from the improvements as between a tenant and a landlord, such that you can get separate identification numbers. That's not statutorily required, but most PACE lenders will absolutely require that this be done prior to closing in order to confirm how the assessment's going to be treated and on which ledger the landlord or the tenants it's going to be put on. Second, does the lease permit leasehold mortgages, and can the PACE lender be a leasehold treated as a leasehold mortgagee? So every ground lease that is financeable has a very long section regarding leasehold mortgages and the right of those leasehold mortgagees to have extended notice and cure rights, the right to obtain a new lease in the event that they foreclose. In addition, sort of acknowledging that lenders, when they step into the rights of their tenants, they're not stepping into certain defaults of the tenants. And so those provisions are critically important for any first lien lender taking a leasehold mortgage as its security. Similarly, those are provisions of concern for a PACE lender, but sometimes it's not crystal clear in the ground lease whether or not a PACE lender qualifies as a leasehold mortgagee. And the reason for that is that A, the statute's just new and people haven't really negotiated this much in ground leases. But B, more importantly, because a PACE assessment is considered a special assessment in the nature of a real estate tax, it theoretically doesn't qualify as a mortgage. So why would they get leasehold mortgagee protection? Contrary to that, at the end of the day, most people consider this a private loan to the project. So what we try to do is when we have opportunities to draft or amend the ground lease is to make sure that PACE lenders have the exact same protections, maybe subordinate to a senior lender as a leasehold mortgagee, so that when they step into the shoes of the project owner, they have the ability to actually get some of the same protections that a leasehold mortgagee has. And that also can give the PACE lender some comfort when it securitizes this on the market, that somehow they have some rights to cure defaults under the ground lease to make sure that their interests are not totally wiped out. Because if the ground lease is terminated, then obviously the PACE assessment would be terminated, as well as any sort of interests associated with the project owner in the PACE loan. We also look to who bears the risk of loss and the obligation to rebuild improvements in a lease. So this is looking at the casualty and condemnation clause in the ground lease to determine who has the right to sort of these proceeds. Note that, statutorily, the way we've analyzed this is that a leasehold interest is considered real property interest under the Texas tax code, and that's why a qualified project can be constructed on that qualifying area. But by being able to do this, we had to navigate several issues with the ground lessor having a PACE loan on it. Obviously, the standard senior lender recognition agreement in terms of notice and cure and sort of trying to figure out disbursement of funds. And what was unique about this was how to sort of get the ground lease to align with some of the terms of the PACE loan and how to make sure it worked out. Now, another thing I'll point out here, which didn't come up in this transaction, but is coming up in another one I'm working on, is that a lot of times, specifically for hotels, major brands that are providing their flag for hotels will require very strict recognition agreements related to their management rights over the hotel. Similar to a key lease, those rights really cannot be recognized by a PACE lender because, like we've talked before, the statutory process to foreclose upon a PACE lien would essentially wipe out any possessory or even management interest that in this case Marriott would have to the project. So this is something that, for hotel owners, this is something just to think about in the back of your head if you're using a PACE loan, if you have a brand managed project, to inform your franchisee or about this and work through some unlikely scenarios, hopefully, of how a workout with a PACE lender would actually work. So some additional takeaways, and then I see we've got a couple of questions. So first, PACE loans are still considered this sort of hybrid. They're probably a loan for federal income tax purposes, a special assessment for state law purposes, but often considered a real estate tax for contractual purposes. And all three of those types of treatments can permit you to make some creative arguments with different portions of the capital stack so that you can put the transaction together. The remedies and timelines for exercising under a PACE loan documents are very strict because the statutes don't give flexibility. You just have to keep that in mind as you're negotiating payment structures, defaults, and other timing elements to give the borrower and the other counterparties to the wider transaction time to negotiate a workout. Because as you saw in the Sinclair example, you could get a notice that you're in default and the lender wants to post it for foreclosure the next day. It's going to take more than 30 days to close a PACE loan or any refinancing. And so trying to figure out how to do that under that time pressure is pretty important. In electing between a direct loan and a bond structure, you just have to bear in mind the cost of the project and the flexibility the sponsor needs. A private loan is a lot easier to call up the person at Petros, Twain, Counterpoint, or other PACE loan provider and say, I've got a problem, can you help me? Versus a special servicer or a trustee for an indenture. who is literally just following a document. And if you're not following the document, they've got to exercise remedy. Just something to think about. A lot of people have gotten bitten in the pandemic by doing bond deals and CMBS deals because of that. So PACE loan underwriting is different than a commercial loan because of the priority of the special assessment. But so it can be really easy to include it in your capital stack. You just have to be wise to some of the tension points that everyone's going to have. Next thing I like to tell people is just pigs get fed and hogs get slaughtered. You know, PACE loans are great as a source of leverage, but don't kid yourself. I mean, from a project's perspective, it's a loan, it's leverage. So don't ask your lender for a 65% construction loan with a 25% PACE loan. It's not market and it's too much debt on the project. And so I even think, you know, there's underwriting concerns with debt service coverage ratio and other things about the project, why that doesn't necessarily work for a PACE loan. All right, well, I think I've talked a whole lot, so why don't we get to some of these questions?
Phil, but I believe Tariq has signed off, so you might jump to the third question from Boris.
All right. What is the average time to close a hotel deal from sale to funding? So in terms of if you're doing a development project, I would say you need to bank on a minimum of 90 days. And that's from term sheet through underwriting, through third-party review, TPA review, and then a lot of times, particularly in some jurisdictions, you've got special review by city attorneys, county attorneys who want to make sure that the project documents comply with the program requirements for a particular jurisdiction. So I would bank on about 90 days, and that can be quick. If you're involving all these other sources of capital, if you're super organized, you can stick it within that 90 days, but usually it's 120 days. So this next question is, can you explain a little bit more how brand names may affect the PACE loan? So brands like Marriott are very aware that their hotel developers are using PACE loans, and they, if they're managing the hotel, now they're asking questions about what special recognition rights they can get for their management rights. That's a thorny issue that I'm not sure the hotel brands have fully thought out. But in terms of incorporating it into your capital stack, I think that the brands are typically pretty indifferent about doing that. I know that in some jurisdictions, it may make some of the local governments very excited to hear particular brands going into their facilities, and then your local government is supporting that project with a PACE loan. And so that is something that is, you know, a lot of people feel are very positive. All right, Mr. Peeler. What are some of the common reasons senior lenders have not been willing to authorize CPAs? Any strategies on improving the likelihood of success? I think for senior lenders, they have to be comfortable with the super priority of the PACE loan. And I've talked to a lot of different banks about the nature of the PACE loan, talked to their counsel about it. And really at the end of the day, it becomes an underwriting decision about what is the strength of the project and its cash flow, and is there sufficient reserves put in place, and how much loan to value is the bank lending against. So more often than not, there's some kind of maybe a half a year's PACE reserve set up at project opening or at financing. That's just cash collateral sitting in a bank account ready to pay a PACE assessment if necessary. Other times it's just negotiating guarantee covenants and cross defaults. And sometimes it's just working through LTV covenants in terms of reducing what would usually be like a 60% loan down to maybe a 50% loan or even lower in the case of the Continental Gym project. And I also think that a lot of times what I'm seeing is that it's really the strength of the relationship between the borrower and the lender. Some lenders, they especially since PACE is still a relatively new financial product, are still nervous about it. And so they have to go explain something relatively new to their loan committee. You know, unless you have a really strong loan officer, that could be a challenge. But what I can also tell you is that a lot of banks see a 40% LTV deal and they are ecstatic about it. And I think that really the tension between the borrower and the bank is usually about how much the bank will lend. And so the borrower obviously wants to say, I want as much PACE loan and as much, senior loan as I can get. But that means that if you put those on top of each other at 25 and 65, let's say, the borrower's only putting in 10% equity. Most banks I know want like 20 to 25% equity. So it's talking about what are those equity requirements and how do they know that the borrower really has skin in the game. And then one regulatory comment, for most acquisition and construction loans in the United States, most regulated banks are subject to what's called the high volatility commercial real estate designation. And so if there isn't a minimum of 15% equity in a deal, then what you're going to find is that the bank can't make the loan, or can only make the loan if they increase their capital requirements, which obviously is very expensive for them to do and they don't want to do. So I would say that for a PACE loan to be in a deal, the highest the bank would ever go would be 60%, so that you're always has 15%, sponsor equity in the deal. Have you seen any USDA-backed projects combined with PACE? I have personally not seen any USDA projects with that. I do know that some of the agency lenders, so Fannie Mae and Freddie Mac, are starting to get more comfortable with commercial PACE. Some are not. It really is just about the size of the deal more often than not, and the size of the PACE loan. Right.
Bill, if I could join in on that real quick, we've got a project highlighted on the TPA website that this was a fairly small rooftop solar add-on to an existing property that qualified for USDA REAP grant in addition to PACE funding, in addition to utility incentives from Encore that helped bring the cost of the project down, so that there was a combination of sources there. More about that's on our website as a case study, and can send you more on that as well. I think that's our questions for now. Phil, if you could jump back real quick to maybe slide 9, if that's possible, and we'll close out for today.
Which one's that? This one?
There we go. That's it. Yep. Just wanted to let folks know that there's an abundance of resources and follow-up for things we've covered today and more, all on our website. The program guide and technical standards that I referenced earlier that's being updated now is there today to look at. That will be updated, and you'll know when there's a new version of that. Different events and trainings like the one we're having today, as well as others, are there under our event directory. We're also going to be putting together sort of a self-paced online contractor and service provider training based on the new program guide and technical standards as well by the end of the year. Different case studies I mentioned, the ones that Phil has highlighted. I think there's a couple of those there, as well as several others. And then service providers. We make clear that these are informational listings, but if you are a service provider, that could be a capital provider, a contractor, an engineer that provides third-party review services, we can have you listed there. There's a process, a form that we look at. So not an endorsement, but informational, because obviously owners that are navigating through this process are looking to turn to experts that have experience. And this is an information resource for them. So let us know. I think maybe there's.
Oh, and hey, Dub, I did want to tell you, for all of the lawyers that are on the phone, we did apply to the Texas Bar to have CLE credit. So if you need a contact form or a sort of course number, we're happy to give it to you.
Great, perfect. And with that, we'll end for today a few minutes after, but that was a very deep and complex, interesting webinar. The types of transactions that Phil highlighted by design are those that are complex, multiple funding sources, et cetera. Not all PACE projects are, but we're happy to work with you, the owners, to work through your project through the PACE process. So let us know. And with that, we will end for today. And hopefully see you next month in Amarillo at the Barfield if you're in the area and would like to see a PACE project. And then the next two virtual T5 webinars, November and December, we'll see you back here. Thank you, and have a good day and stay safe, everyone.